725 readies. These are folks who let the college know, who have already let the college know that they've included Reed in their estate plans, either directly or through a charitable trust or donor advised fund, otherwise. Fun fact is approximately 50% of bequests that come to the college are from members of the Eliot Society and are known to us in advance. So that means that the other half we never know about until it's too late to say thank you. So if you've done that, let us know, we can thank you. Some of you may have followed the link in the invitation email to this event and read the wills of Simeon and Amanda Reed, which taken together provided for the establishment of the college. Simeon's will dates back to 1978, and he left everything to his beloved Amanda in what was a one-page sort of aspirational, I think it's a love letter, but an aspirational hope that she would use the wealth to increase the intellectual environment, the knowledge of Portland citizens in literature, sciences, and the arts. And I've always been struck by the fact that he made the bequest at a time when most states denied women independent right of property ownership. And ratification of the 19th Amendment was still 40 years away. So it's Amanda's will that we see the creation of this Institute of Higher Learning, which we know as Fair Reed. So the Eliot Society recognizes their generosity and the generosity of so many Reedies who followed in their footsteps. I say sigh on the shoulders of giants. So that was my evangelical moment. And to the program, I will turn to how extremely fortunate we are to have with us today 3 Reed lawyers who have many, many years of experience in different parts of estate planning. First is Susan Scher, Reed class of 1986. Susan is celebrating her 35th Reed reunion today. She's from Los Angeles, has her own practice, which is devoted to estate planning and small business representation. Susan works with individuals in estate planning, probate, trust, all matters of administration, and considers herself to be a heart-centered attorney, not something we often hear. But having known her for a number of years, I completely agree. Today, Susan will talk about the basics of estate planning strategies. We received lots of questions from folks in advance. Some of you are very interested in that. After Susan, we'll hear from Vanessa Usui. Vanessa's Reed class of 1996, and she is celebrating her 25th reunion. She is an attorney here in Portland, works at Duffy Keckle, and focuses practice on estate and tax planning, trust administration, charitable giving, charitable organizations. Her special expertise is in tax efficient estate planning. I know we have some questions on that front. So she'll touch on that in her early remarks, as well as a little bit on international estate planning. So we have about 6 people who RSVP'd from other countries. Finally, Mark Scher, who is class of 1986 also, 35th reunion, is a shareholder in Los Angeles at the firm of DeCastro West. Mark's a litigator, and among many, many other things, he focuses on probate and trust litigation. So he is the person who can tell you the pitfalls of not having a well-designed estate plan, and is going to share with us some maybe terrifying tales from the trenches. So before I turn the screen over, I'd like to just let you know about our format. Each presenter is going to say a few words about their special area of estate planning, after which we're going to move into breakout rooms. We'll be in the breakout rooms for approximately 30 minutes of Q&A. So that's where you get to ask all of your burning questions. If you have a question for a specific presenter, sorry, that's my puppy seeing a squirrel. Make sure you join that breakout room. If you have multiple questions for different presenters, you can move between breakout rooms. Santi and I will be hosting a 3rd breakout room for those of you who might have questions about including Reed in your estate plans. Or maybe you just want to know what the impact of these types of things are for Reed. So I can say bequests have historically been the single largest source of support for the college. Anyway, after the breakout, we're going to reconvene and reconvene in the big group, and we'll have final takeaways from our estate lawyers, and then you'll be able to ask any final questions or make comments that you have. And maybe if we still have some time left, Santi will finish the trivia questions. I think that's it. With that, I am going to turn to our first presenter. So Susan, share.
Thank you, Kathy. Can everyone hear me okay? Yes, thank you. So I am privileged to open today's estate planning discussion by talking about some of the basics of estate planning. And I thought I would begin by talking about some of the terminology. To begin with, what is estate planning? I'm going to give you a rather narrow definition, which is the transfer of assets after death. And when I say it's a narrow definition, that's because as opposed to transferring an asset after death, we can transfer assets during life, and that's called making a gift. And as you'll see later, with more sophisticated estate planning, gifting actually becomes quite important. But for our purposes, we're going to focus on transfers of ownership of assets after death. So what exactly is meant by an ownership of an asset? So ownership is, when we talk about legal ownership, we're talking about how we hold title. So how can people hold title to assets? So if you think about, many of you may own your own home. And if you own it with your spouse, you may own it in what we call joint tenancy. That's one form of ownership. And when one joint tenant passes on, then the other surviving joint tenant owns the entire house. And that is what we call by operation of law. It just goes automatically to the surviving joint tenant. And what if you've designated a beneficiary, let's say on a life insurance policy or on a bank account or on a retirement plan? Well, then the asset will transfer on your death to your beneficiary who has been designated. And we can also sometimes designate more than one beneficiary. Often we can designate charitable organizations or financial or educational institutions. It's not only individuals who can be designated as beneficiaries. So those are some forms of ownership of assets. Now, sometimes though, we just own an asset in our individual name. And sometimes, we are unable to make an account, either POD, payable on death, or TOD, transfer on death, and we don't have the option of designating a beneficiary. So, or we become the surviving joint tenant. So what happens then when we have an asset and there is no way to transfer legal title without doing something else? And so that's what we're going to focus on today, on doing that something else. And that would mean either creating a will or creating a trust. And I'm going to discuss the distinction between the two in just a moment. But before I do that, I just wanted to take another moment to talk about what an asset is, because we have different types of assets. And there are two broad categories of assets. They can be tangible or intangible. If they're tangible, that means, we can touch them. So a house or a car or jewelry, those are all tangible assets. Intangible assets are things like our intellectual property, like a copyright for a book we've written, or a patent on a design for something we've created. So how do we transfer those assets to our objects of our bounty, they are called. And who are the objects of our bounty? Those are our loved ones, family, friends, or a charitable organization that we like to support. Okay, so many people ask me, what is the difference between having a will and a trust? So a will is what we call a testamentary document. That means it takes effect on death. Now, by contrast, and there are many types of trusts, I will preface it by saying that, but the kind of trust we're going to focus on is called an inter vivos revocable trust. So inter vivos are the Latin words that mean among the living. And this type of trust is one that would go into effect during a person's lifetime, when they sign the document. And I would like you to think of a trust as a box. And we put all of our assets into that box. And by doing so, we are funding the trust. And this is the important thing. A trust would just be a whole lot of paper unless we fund it. We actually transfer assets into it. And how do we do this? That's why that idea, that notion of legal title is so important. We transfer assets to a trust by changing the way title is held. So if I own my home in my own name, Susan Scher, as an individual, then I can transfer it to my trust by way of a grant deed. And so this is a written document that then gets recorded with the county recorder where the real estate is located. So that's how I would transfer my house into my trust, and then I would own it as Susan Scher, trustee of the Scher Family Trust. And if I wanted to transfer title to my bank account or my investment account, well, then I would need to deal directly with the financial institution and get the title changed so that it is in my trust. And that's reflected on the statement. Now, why do people desire a trust rather than a will? Now, I started to say a will is testamentary. It takes effect on death. A trust this type takes effect during life. What's the significance of that? Well, if I become incapacitated during my lifetime, then my trustee, my successor trustee, can use the assets in my trust for my own benefit during my lifetime. And I can't do that with a will because it only takes effect when I pass. Another reason I think that a trust is preferable in many instances is because it is a private document, whereas everything we file with the court is public record. And a lot of these affairs we do wish to keep private. Now, sometimes a person doesn't have a will or a trust, and they might have assets that are valuable and need to be transferred, but they are not designated in the ways that we have talked about. So these become what are known as probate assets. That means, and what is probate? Probate is a court-administered process that transfers assets, ownership of assets. So if a person passes with a will, they may very well need to have that will probated. And if they pass without a will, but without a trust and they have assets, they'll still need to go to probate. The difference here is that rather than drafting your own will, where you can specify who you want to receive what, instead, the state you live in this case, let's look at California or Oregon, has already come up with a will for you. And the way that gets instituted is via what we call the probate code. And this law is statutory. It exists state by state. And generally, it makes a lot of sense. So even if you die and you don't have a will, basically the state has set forth in the statutes or the legislature that your assets are going to go to your nearest relations. And there's a priority order for that. And it does make a lot of sense. But sometimes we want to leave things to people other than our blood relatives. Sometimes we just don't even like them. So then a will becomes very important. Now, let's shift for a moment to a trust. Now, a trust might be preferable because instead of just leaving an asset to an object of your bounty, whether that be an individual or an institution, you can actually specify a lot of specific distribution instructions. So you can say, oh, I want the income to go to a certain party for a certain period of years. I want the principal to be distributed to my children in intervals when they reach ages 25, 30, and 35. And so there's a lot of reaching kind of from the grave, if you will, where you can specify what happens even after you've passed on. So that's another reason people like using a trust of this type. Now, I wanted to talk about kind of the parties to each of these documents. So for a will, the person who writes the will is called the testator. The person who would then administer the will when the testator passes is called the executor. And then the people or institutions who would receive the assets are called the beneficiaries. If the person who passes does not have a will or trust, and their assets then go through probate via what we call intestacy, then the beneficiaries under a will, the analogous term there would be the heirs, because they're your heirs at law. Those are, the relatives, the blood relations. Now, let's look at the terminology of the parties in a trust. The person who establishes the trust can be referred to as the settlor, or the grantor, or the trustor. All means the same thing. You've established the trust. The person who manages the assets is known as the trustee, and ultimately, whoever receives those assets are the beneficiaries. Now, the interesting thing is that if you establish the trust, you are, as I said, the settlor, but you are also generally the initial trustee of your trust, and you're even the initial current beneficiary of your trust, because you are all of those assets you put into that box, they're for your benefit during your lifetime. So you have three roles: settlor, trustee, and beneficiary. Then, if something should happen to you and you're incapacitated or you pass on, the person you've already nominated to be successor trustee, and I like people to nominate a bunch because sometimes people just can't act in that role when the time comes, that individual will manage your assets either for your benefit during life or distribute the assets in the manner that you've already set forth after your passing. So, a lot of people, I'm not sure I mentioned, I think I did, that we call that court-administered process probate. So another benefit to the trust is that you avoid probate. And I'm sure everyone has heard that term, avoid probate. And that's because the probate process is costly, but more than that, it's actually very time-consuming. And many times the court is supervising everything. And when your assets flow through a trust, you don't have that same oversight. The trustee, and I love that term, trustee, because it shows that person has to be trustworthy and responsible, and they have what we call a fiduciary duty. So your trustee can take care of all of that without the court oversight, but they, as I said, do have this fiduciary responsibility. What if you are a person, and I know this was one of the questions, who really doesn't have someone to nominate in that capacity of trustee? Well, there are actually people who are what we call professional fiduciaries, and this is their career. They have a certification to act in that capacity. And usually, while they do charge more for that service than, let's say, a family member might, they usually charge a lot less than an attorney would for acting in that capacity of trustee. So for those people who don't have someone, that might work. Also, there are, trust departments of banks and, trust companies that will act in that capacity. Okay, so we've talked about the different, probate. We've talked about the difference between wills and trusts. We've talked about some of the terminology. So let's talk about some of the other types of trusts for a moment that exist. There are, I've mentioned this inter vivos trust. We also have trusts for other purposes. We have charitable trusts, and those might be either charitable lead trusts or charitable remainder trusts, just meaning, when the charity will benefit from the assets. And while I talked about what I call a revocable trust, there are also irrevocable trusts. And that means that they can't be changed, although that also is open to modification via going to court. But generally speaking, that's what irrevocable means. And in fact, when you do pass away, if you have a revocable trust, when you die, it becomes irrevocable, because you don't want other people changing the parameters of your trust when you're no longer here. So I think that makes a lot of sense. Okay, and in addition to a trust, I always prepare a will for my clients. It might not be the kind of will that states what the distributions are of their assets, but it's called generally a pour over will, and it's used in conjunction with a trust. And really what it says is that I give all of my assets, whatever they might be, to the trustee of my trust, and then the trust handles what then ensues. So it says very little. But one important thing for younger, let's say, people who have, perhaps young children, is that we can designate potential guardians of those children in the will. And this is, thankfully, I have never actually had that happen where I need to call that into play, but it is very important to still, have that written out so that if something should occur of that nature, there are guardians who who it will be and who will nurture and raise your children and use the assets in the trust in order to take good care of them throughout their lifetimes. And in addition to the will and the trust, there are other important documents to a good estate plan. Powers of attorney are extremely important. Now, a power of attorney only is effective during your lifetime. And we can have various types of powers of attorney. We can have financial powers, and then we can also have healthcare powers. And right now, in light of what we've all been experiencing over the past year and a half, it is even more crucial than ever to make sure you have a valid healthcare directive. And that's because if you don't have a spouse and you are in the hospital and you can't communicate with the doctor, you need someone who will be able to communicate with the doctor on your behalf. And we do that by nominating an agent in a healthcare directive. Now, I think I am running up against the clock and it's time to turn things over to Vanessa, but I will talk more about powers of attorney and various other supporting documents in an estate plan in the breakout room. And so now I turn it over to Vanessa to talk about some of the tax complexities in estate planning. Thank you.
Thank you, Susan. So I'm just going to start with a basic background on the different types of taxes that might come into play when you're doing your estate plan. So first off, there's an estate tax. And these taxes can be imposed both federally and statewide. So an estate tax is a tax that is imposed upon the value of your estate to the extent it exceeds an exemption amount. So currently, and this has been a lot in flux, and I'll talk about some proposals in a second, but currently there's a federal estate tax. The rate is 40%, but it doesn't kick in until the value of your assets is 11.4 million per person. So a married couple with advanced estate planning techniques can transfer at least $23 million to their heirs without having an estate tax. Now, there are various exemptions to the estate tax. So for example, you can leave unlimited amounts to your spouse or unlimited amounts to charity. So we oftentimes will do planning for married couples to defer the tax until the second death by taking advantage of that marital deduction. Then there are about 12 states that have a state level estate tax. So for example, there's an estate tax in Oregon for your assets over 1 million. That rate is 10 to 16%. There's an estate tax in Washington for assets over 2.2 million. It's a little bit higher. It's goes up to 20%. California doesn't have an estate tax. So for many folks, planning for the state level estate tax is a big part of their planning because it might be more likely to impact them. A few states have what's called an inheritance tax, and that is a tax imposed upon people who inherit the assets, depending upon their relationship to the individual. I'm not as familiar with them because they tend to be more southern states. My understanding is that there's usually an exemption for amounts that's left to close family members. It's more along the lines if you're leaving it to extended family or friends. So in addition to, there's some newer features to the estate tax. I should say that the exemption of 11.7 million is remarkably high right now. It's not that long ago that it was 600,000 or between 1.5 to 3-ish million. There is a feature of the federal law called portability, so that even if you don't do any estate planning before death, your spouse can inherit your unused exemption. So thereafter, you'd be able to give right now about $23 million. The statute that's written right now with the $11.7 million exemption is set to expire at the end of 2025, at which point, barring any action from Congress, the exemption will be cut in half. So we estimate it'll be between $6 and $7 million at that time because it is inflation adjusted. In addition to that tax that's imposed on your estate, there's a second level of tax called the generation skipping tax, transfer tax, that's imposed if you leave assets to family members who are 2 generations or more younger than you, or people who aren't family who are 37 and a half years or more younger than you. And the idea here is, imagine that I have children and grandchildren. If I leave assets to my children, then I have to go through the estate tax gamut. And if they then leave assets to their children, then it might be subject to estate tax a second time. So people got smart and they skipped that generation and they just gave the gifts directly to their grandchildren. Well, to avoid that, the IRS would then lose a level of tax. So to avoid that result, there's this other tax called the GST, Generation Skipping Transfer Tax. Its rate's also 40%. Currently, you also have an $11.7 million exemption. And I'm not aware of any state, although there might be a few that have a state level GST tax. It's really more of a federal issue. The one thing though, that portability I talked about, where you can inherit your spouse's unused exemption, that doesn't apply to GST tax. That's just for the estate tax. It's sometimes a surprise to people, but there's also a gift tax. So the gift tax is a tax on the transferor. If I make a gift to somebody else, I'm responsible for paying the gift tax on that gift. Now, there's an idea of some de minimis gifts that you should be able to give so that you don't have to pay a tax every time you give somebody a birthday gift. And so currently you can give $15,000 per person. So for example, a married couple can effectively transfer $60,000 per year to their married child because each spouse can make a gift to each spouse. And so those are called exemption gifts. They don't have to be reported to the IRS. They're just sort of freebies and you can do it every year. Currently, it doesn't have to be cash. It could be business interests. It could be, fractional shares in real estate. And there's lots of things we do to structure different types of gifts. For example, maybe we have a life insurance policy inside a trust, and we make the premium payments by using that exemption, so that then the beneficiaries later can get the life insurance when you die outside, and that wouldn't be subject to estate tax. The gift tax rate is the same as the estate tax. So to the extent that you make gifts that exceed your exemption of $11.7 million, it's a 40% tax. But while you're making gifts beyond the $15,000 per person, there's a requirement or an obligation to file a gift tax return, but there's no tax due until your cumulative gifts, either at death, either during life or at death, exceed that 11.7 million. So there's a lot of planning we do to kind of plan around these taxes or minimize them or defer them. But there's always this other, I always think of things in estate planning with tax as being a pro-con, and the con oftentimes are some negative income tax consequences. And more, the income tax issues are becoming a larger deal for most folks because not many of us have $11.7 million to worry about who we're leaving it to, whereas income taxes might be more of an issue. So under the current law, and this has been the law for 100 years, when you die, you have what's called a step up in basis. So if you have stock that you bought for $1 and it's worth $100 when you die, that $99 of capital gain is forgiven. When your heirs or your beneficiaries inherit that stock, their what's called basis in the stock is $100. So if they sell it the day you die, they're not going to pay any income tax. There'll be no capital gain. Whereas if you'd sold it while you were alive, you would have had to pay tax. So sometimes if we're not worried about people having to pay estate taxes when they die, we maybe don't want them to be really aggressive in gifting, because when you make a gift, we have carryover basis. So you don't get that step up and forgiveness of capital gain. So sometimes the overall taxes will be less, even if we end up having to pay, let's say, Oregon estate tax. That rate of 10 to 16% could very well be much smaller than the capital gain rate on the appreciation in an asset. So, more advanced estate planning, you have to sit down and run some numbers to see what makes sense to sort of minimize the taxes, because it might not always be intuitive as to what the right result is. Now, a lot of this, Congress can always change things, and there's lots of proposals right now. There's probably about 5 different proposals floating out there to change some of these areas. And I've given up trying to predict what Congress would do. I would never have thought that the exemption would be $11.7 million. When it got to $5 million, we thought that was madness. So here we are. There are some proposals that might change that impact of that step up in basis in assets, and it might actually impose an estate tax when you die, or an income tax when you die on the appreciation in your assets. There are some proposals that would impose an income tax if you made gifts, especially into some of these trusts, and maybe would change sort of the period of time that assets can pass down to generations without being subject to further taxes. And I'm happy in the breakout room, if you have specific questions on that, I can address them. But right now there's so many moving parts, and who knows what might actually get passed, that I just generally tell people what's being proposed, but I have no predictions as to what we might actually end up with. There were some questions on international estate planning. And the main thing that I will say there is that when you do your estate plan and you have assets in more than one country, there's generally 2 ways you can handle it. One is to have one estate planning document that governs both jurisdictions. And then you need to work with either an attorney who's licensed in both jurisdictions, which is not that common, or you have 2 different attorneys who work together to create that one document that'll govern your assets in both areas. Another option, which is maybe a bit more common, is to set up your estate planning documents to be clear that they only govern the assets in that jurisdiction. So you would have a US situs will that said this will only covers assets that are located or deemed to be located in the United States. And then in the other jurisdiction, you have a similar document. It's dangerous, and you want to be very careful about having just your US estate planning documents without somebody doing some research about how that might impact your foreign assets. And that's because, for example, Susan gave a great explanation of trusts. Well, trusts aren't recognized everywhere. So there are some jurisdictions in which they don't know what a trust is. It's a very foreign concept. It wouldn't be recognized. So if you had an estate plan in the US that said, I leave all of my assets in a trust for the benefit of my child, that might not work in a different jurisdiction. Furthermore, a lot of jurisdictions have begrudgingly accepted trusts in limited extent, but maybe have time limits on them. So for example, in some places, trusts can only exist for 50 years or less. They also may impose income tax consequences. So, you don't want to leave assets in trust for a beneficiary who's not a spouse in the UK or in Canada, for example. In Canada, there's a deemed disposition tax. That trust will be deemed to have sold its assets, and the related capital gains tax has to be paid every 21 years. In the UK, I believe it's even shorter than that. I can't recall. So you want to be, if you have assets in multiple jurisdictions, you want to be working with folks who understand those laws and can parse it out. The other aspect I'd say about international estate planning is if you are a US citizen or a US resident, your worldwide assets are subject to the US estate tax. It is not just your assets that are located in the US. However, there may be some inheritance or estate taxes in the other jurisdiction, and there are oftentimes treaties to avoid double taxation. So if I have a client that has assets both in the US and in Canada, there's a Canadian income tax that is imposed when you die, but you get a credit for the payment of that tax when you look at your US taxes. So I have to file on the US estate tax return. I have to report those Canadian assets, but then I get a corresponding credit for the tax that I've already paid. And if it was less, I'd still pay the difference, but generally it's more. And so that's a benefit to if there's a treaty. I think there are some jurisdictions where there's not a treaty, and so you'd want to be aware of that because you could end up in a situation where you're having to pay taxes in both jurisdictions, which is not a result that people want. And then I'll quickly, with my kind of remaining time here, talk a little bit about some of the proposals. There's the Biden tax proposal. I think that's the one that people are focusing on the most right now, just because it is the president proposal. It's called the Green Book. It may have more of the likelihood of passing. It's definitely going to sort of change the landscape a bit by imposing some capital gains tax and increasing the rates there. There's also, in some situations, we set up trusts that are intended, they're called dynasty trusts. They're intended to go on forever. They're set up in states that don't have a rule that say that trusts have to end at some point. There may be some of the tax proposals would start imposing a tax on those either at every 50 years or every 90 years. I think that's, those are the main things. There's some more advanced estate planning techniques that we do where we make completed gifts for people so that the appreciation of the gift isn't ever subject to tax, but you actually retain the obligation to pay the income tax on those trusts. They're called grantor trusts. And on one hand, it sounds like a terrible idea. I've given away this asset, but I'm stuck with a tax bill. It's actually very efficient because I have a legal obligation to pay that tax bill. So when I pay the beneficiary's taxes, I'm not making an additional gift. There are some proposals to maybe cut that back or put that back into my estate. So, we're a little bit in a situation with some folks who are trying to do some more complicated estate planning of making some guesses as to what we might think would happen with the law and ways that we might be able to plan around that. So I think with that, I'm happy to answer any questions that people have about taxes, both estate tax and income tax. And also if you have Oregon specific questions or Washington, I'm licensed in both states in the breakout room. And I will turn it over to Mark.
Hi, Vanessa, thank you. Hi, Mark. So I'm going to talk a bit, but I'm not going to do a breakout room because I'm going to assume everyone here doesn't want to fight today, but they're going to try to think about their estate plan. And like Kathy mentioned, my involvement with trust in estates has more to do when things go wrong. And a lot of things do go wrong. And one of the popular programs I give each year around Halloween is called Collecting from the Dead, which just has to do with debts owed by decedents. That's a whole interesting area of law. But today what I want to talk about was a little bit about things that go wrong in the estate planning process and why it is worthwhile, if you want your wishes fulfilled, to go to an attorney. So the first of all question is like, do I need anything? Can't I just die and it'll be taken care of? So we all know that if you die without a will or trust, all your assets go to your state of residence. Now, that's not really true. In each state, there's an intestacy law. So the state has a estate plan for you, and it basically goes to relatives in a sort of statutorily defined family tree. But that may not be what you want. And furthermore, it has to go through probate, and you may not want the person appointed executor who the state would have appointed. That's generally not acceptable, for most people. So the next question is, well, can I just write my own will? And you can, but the courts are so afraid of fraud in that situation that a lot of times they're challenged, or the person, they're just not accepted. Like if they're not totally in your handwriting, but they're partly typed or printed on a computer, it may not be accepted. Wasn't what, there's a lot of issues with those. Again, you risk not having whatever you want to have happen. I really think going to a lawyer is just like any expense, like going to a doctor, buying a policy of insurance, or having your car maintained or something like that. It's just something responsible to do. If you have heard about a will versus a trust, and I would agree that a trust allows for more flexibility. But another good reason to go to a lawyer is, the problem is once you're dead, you can't tell anybody this is my will and trust. Someone else is going to have to do that. And if the person, let's say, who's most likely going to find it in your home or whatever after you pass, doesn't like the disposition, maybe they would do better under the intestacy law. Or maybe you revoked your trust and you have a new trust and they like the prior version. The current version might disappear. And there is a presumption in the law that if your will or trust can't be found, that you revoked it, even if you didn't revoke it. But if you had an attorney, we attorneys, we're like hoarders. We keep copies of everything. It's crazy. So there's, again, a better chance of your wishes being fulfilled, because you would be just surprised at the number of things that disappear from someone's home when they pass, whether it's grandma's china or a piece of jewelry or a will or a trust that somebody doesn't like. The other reason to work with an attorney, as opposed to using, let's say, your own form of a will or a trust that you find on the internet, is that a trust is a box. It's like a corporation. It holds assets. It's just a legal fiction. And that means that if you just create a corporation, it doesn't own anything. If you just create a trust, it doesn't own anything. And a lot of people don't title assets in the trust before they pass. And if they don't, then you're still going to have to go to court to say, should this house have been in the trust? Should this stock portfolio be in the trust? Or was it meant to pass by a will or something else? Was there a different beneficiary statement? So that's important to flesh out. And frankly, a trust is much more complicated than a will. And I've seen so many times when, from a lawyer's point of view, looking at the document, it's kind of gobbledygook. And it probably was gobbledygook to the person who downloaded it from LegalZoom or something like that. And again, you would just end up back in court again. And so then a lot of your estate will be used in legal fees instead of the money going. Also because those people who are charitably minded may want to leave money to a couple charities. There's a lot of charities with similar names. And although I suppose Reed College is pretty clear, other charities like, an animal welfare group or something, there may be lots of similarly named charities or differently named. And the lawyer can help you make sure, again, that things are named properly. I can remember, one recently was someone left an apartment building to City of Hope, which is a medical center for cancer in Duarte near LA, but like the building wasn't properly described. And, again, that's something that could have been handled better at the beginning. An attorney can also help advise you on your choice of trustees. I'm in litigation right now. If someone chose their business partner to be their trustee instead of any of their kids. Well, the problem is the business partner has a conflict of interest because he's continuing the business. If you give him control over your business interests after you're dead, he's probably going to keep skewing things to help himself instead of your kids. And he may justify, well, I'm surviving, I have control of the business. So that may not be good. So it's a really important decision who your trustees will be. And another reason you want to go to your attorney soon and often is because these laws change. And Vanessa was right, the tax laws change. That's one of the things that makes anything hard for us, because after we look for a while, these things keep changing and we have to learn them anew, whether it's Apple changing the processor in all their computers or anything that changes. And so one of the things that's changed is tax law, and that's changed the way estate planners have written estate plans for regular folks. Because like Vanessa said, in the old days, like if you go back to the 90s, when it was a $600,000 exemption per person, then pretty much everybody needed some tax planning. Or if you lived in a city like LA where houses were expensive, you kind of needed an estate plan and some tax planning. And you'd want to put half the estate that worth up to $600,000 in a separate irrevocable trust, so it wouldn't be included in the survivor's estate when he or she passed. But so again, the state tax was the big issue, but there's this other tax that Vanessa mentioned, which is just income tax. And income tax means taxes on your wages or taxes when you sell anything that's appreciated in value. And those are called capital gains taxes, but it's really just a type of income tax. And so then the income tax became more important because you wanted, what Vanessa described, the step up in basis. So you wanted everything to go up to market value when the second spouse died. You didn't want to lock anything into the decedent's half of into a decedent's trust, because you would avoid estate tax, but you wouldn't get the step up in basis to current market value when the second spouse died. And that wasn't important once the exemption went from 600,000 to 11.7 million. Now, at least, except for the very wealthy. So then people who had these trusts set up that were designed as what they used to call AB trusts really just wanted everything to go to the survivor, unless special circumstances like they had children from a prior marriage and wanted to make sure those kids got something. But for tax reasons, you just wanted everything to go into one pot for the survivors to get this step up in basis. Now the law is changing again. Both these parts are changing. The capital gains rate is essentially going away. That's what Biden wants. We don't, in California, where I practice, we don't have a capital gains tax. If you sell your shares in Apple or you earn money at your job, you pay the same tax rate. But under federal law, you pay a much lower tax rate. You pay 20% instead of whatever your bracket would otherwise be. So Biden wants that to go up to, if you add in the Obamacare, which is 3.8%, it's like 43.4% of tax you would pay when you sold shares of Apple or when you sold stock. And so the income tax on the capital gains will go up. And then he also doesn't want to have a step up in basis to market value when somebody dies. It'll be like a deemed sale. It'll be like when somebody dies, the government will treat it as if the decedent sold all their assets, except for a $1 million exemption per person, so $2 million for a couple, plus $250,000 for the house, or $500,000 again for a couple. So up to $2.5 million written off. Above that, it's a deemed sale, and assets have to be sold to pay that tax. Who knows what will happen? But again, if you want to go back to make sure that that your estate plan is tax efficient. And I think it's unfortunate as social policy, because taxes should just be to raise money. It shouldn't be to affect the way people conduct transactions, but that's the way it is. The other reason I recommend going to the estate planner frequently is because if you have an estate plan that has anything, most people have somebody that they don't want to leave money to who might seem like there might be a kid even, and in some European countries, it's not allowed legally to disinherit a child. But in America, it is. It's the parent's money and they can do what he or she wants. And if you want to avoid litigation at the end of the day, it can be helpful to, let's say, make amendments, even minor amendments to your trust going forward, so that even if the last trust is revoked, because let's say you're 99-year-old, let's say somebody says you didn't have all your marbles when you made it, you just go back to the previous trust, which has essentially the same main terms of disposition, leaving things the way you want. It helps strengthen the case that what you want to have happen will happen. And finally, an estate planner can come up with the best ways to document your intent, whether that's writing a side letter stating this is what I want to have happen, or a video, which may or may not be helpful, things like that, a doctor's examination. So the key is, it's important to recognize that the money is yours As we get older and really old, kids who themselves will be older will tend to treat the money as theirs because they're already looking at it as an inheritance. And I'll tell you, if the estate tax changes and so that anybody who dies on January 1, 2022, those estates are going to suddenly be a deemed sale at 40% tax rates, there may be a lot of parents who, mysteriously die in their sleep on New Year's Eve of this year. So if you, to maintain this this control and make sure what you want happens, go to your estate planner and document your wishes. So, turn it back. Kathy, you're on mute.
I think I muted you guys. Wow, thank you so much. That was amazing. It is time for us to go into breakout rooms. We'll have a chance to come back and thank Vanessa, Mark, and Susan at the end, ask additional questions. But for right now, I want to remind you of, you have heard everyone and know what their general areas of expertise are. Mark and Susan will be in a room and Vanessa will be in a different room. I think Mark's joining. If you are not, then it will be Susan in that room. And Santi and I will be in a room that relates to Reed and charitable gifts if you're interested in that. But I think most everyone over the past year has become facile in navigating Zoom. The breakout rooms are now open, or they should be open and should appear at the bottom of your screen. I'm trying to see if mine are there. Fiona, are they there?
Yes, I just opened the breakout rooms.
Ah, thank you. So to join a room, you should click on breakout rooms and hover your cursor over the room, the number to the right of the room that you want to join, and the button join should come up. So you should click on that. If for some reason this isn't working on your computer, just stay where you are and Fiona can put you in the room that you want to go to. And with that, we'll break for 30 minutes to Q&A in rooms and we'll reconvene thereafter.
Reserve a home, but it really could apply to other objects you love, maybe a collection of thimbles or anything, to try to preserve that after you pass in ways that might work out.
Some charitable stuff.
Yeah, we talked about some charitable issues. So I think it was a productive talk. I always love talking to fellow Reedies. We had a nice time.
Excellent. Thank you so much. So I'll move to Vanessa next. Can you recap your group?
Yes, thank you. So we also had a pretty great variety of questions and some really good questions. I think one thing that I didn't mention, but I had intended to in my main presentation, so I'll quickly add this now, that we talked about was some changes that happened in the end of 2019 to retirement accounts. So it used to be you could leave your retirement account to your kids and they could use their life expectancy to draw out the account. And so that was a great way to have some tax deferral, because when you have to withdraw amounts from the retirement account, you've got to pay the corresponding income tax. And if you name like a grandchild or a child, they have a long life expectancy, they only have to take out small amounts. And so you get to have this tax-free growth continue in the retirement account. Well, those options are more limited now. If you leave your retirement account to somebody who's not your spouse or a disabled beneficiary or a disabled or minor child, they need to take it out and pay the corresponding income tax within 10 years. So that's a pretty big change, and that has an impact on a lot of people's estate plans. So we discussed that a little bit, because you may have set up an estate plan where you named a trust for the benefit of a child as a beneficiary of the retirement account. Some of those don't work very well anymore, and you may have set up this trust to protect the assets from the child's creditors. And depending upon the terms of the trust, you may have a situation in which the retirement account has to flow through and out to the beneficiary 100% within 10 years, which is exactly what you didn't want to have happen, because you were trying to keep the money out of their hands, either because they were a spendthrift or they had creditor problems. So it's always a good idea. I tell clients, if you hear about a tax change in the tax law, or if you have a personal change in your circumstances, you want to review your estate plan. Not all estate planners, just because we have so many clients in so many different situations, most of us don't affirmatively go out and reach out to our clients and say, there's been this tax law change. And this is how it's going to impact you. We rely on clients sort of hearing about it or making their periodic adjustments every few years, and then we make those changes. So it's definitely, if you've got something in place, worth looking at. That's a pretty dramatic change in the law that happened that we hadn't anticipated. So I think there are estate plans out there where some modifications might be necessary. We had some questions about, maybe you have a family home that you want to keep for the benefit of extended, multiple generations into the future, and using like an LLC structure or a tenancy in common structure is a good way to do that, because in either structure you can have a governing document that sets out how expenses will be paid, how people get to use the property, what people can who they can transfer it to. Can they leave it to their creditors? Can they leave it to their spouse? Or what if somebody wants out? What are the rules as far as the other beneficiaries buying out that person's interest? And if you've got, if you're at the top generation, it's much easier to come to an agreement and write that document than if we've got a couple generations down and now we have 20 cousins that own this property. They may have very different ideas. They may live in different states, and it can be very hard. It's kind of herding cats to get that done. Like I just finished a transaction with somebody, it was two brothers who were buying out their family farm from their sisters. They had 8 sisters. So I had to get 8 people to agree to the sale terms because the brothers were not willing to negotiate individually. So we had to get all 10 in agreement. And we succeeded amazingly, but it was not easy because they all had different circumstances. And in that situation, the parents didn't set up sort of that structure. They just each owned 1/10 of the family farm. So those are the kinds of things that you want to think about. Definitely gets worse with multiple generations, but sometimes in big families, it could be that first generation too, especially if they don't get along. We also talked about something that with changes in tax law, the standard deduction now is so high, and there's a cap now on your ability to deduct income taxes that a lot of people are no longer itemizing deductions, and they are instead taking the standard deduction, which has a negative impact on your ability to get an income tax benefit for your charitable contributions. So what we've been recommending a lot of clients do is what we call bunching. So we have you transfer a bunch of money in year 1 to a donor advised fund. Go ahead and itemize that year because you've made a substantial contribution to charity. And then you can use a donor advised fund over the next few years to make your charitable gifts. So it's great from an income tax perspective. It's also, I'm finding a lot of clients love it because they no longer have to keep track of all of the receipts from the charities. They don't have to write out checks. They just go onto a website and they say, I want to leave Reed X dollars, and they hit go and it's done. And so it just really takes a lot of the administrative upkeep and paperwork. It takes that out of your hands. And so that's a great option. So both for an income tax reason and also just to make your life easier. So that's something I definitely would recommend to clients. And then there were some questions about, why things might be left in trust. It isn't just because a parent was concerned that a child would misspend the money and be a spendthrift, but a trust that somebody else creates for your benefit also provides creditor protection. So if you get divorced, that trust isn't an asset of the divorce. If you get into a car accident, the creditor can't go after them. If you're a surgeon or in a high liability profession, the trust can provide some creditor protection. So sometimes it's a way for, you can still be the trustee maybe and the beneficiary, but it's a way for another generation to provide some protection to a younger generation. And I think there was a question here. If you have a lot of assets in retirement funds and foresee that they'll land in your trust and your beneficiary is a spendthrift, you should not receive the funds in the initial 10 years. Oh, so yes. So what you do is, and I will give it with the caveat that you want to work with an attorney, trusts and retirement accounts do not play nice together. There needs to be very specific provisions in the trust to not cause some negative income tax consequences. But if you've got a spendthrift beneficiary that you want to be the beneficiary, but you don't want them to get the assets within 10 years, then you do what's called an accumulation trust. So the trustee withdraws the funds over 10 years from the retirement account, but then they sit in the trust. And then the trustee is the gatekeeper to decide if and when money goes to the beneficiary. So there is a way that we have to handle that. We do have to put some additional provisions in the trust to make that work. So for example, you have some limitations on contingent beneficiaries being charity in that circumstance. But it used to be a really bad result if we screwed this up because we had life expectancy versus 5 years. If you screw it up, it's 5 years. Well, now we have 10 years versus 5 years. So for some clients, they're violating the rules anyways, because who cares? Like 5 years isn't that big of a deal for income tax with deferral. So again, talk to folks, accountants or estate planners could definitely walk you through what works best in your circumstance. And I think that kind of covers a lot of what we discussed.
Great, thank you, Vanessa, appreciate it. We've scheduled out, we still actually have another 15 minutes, so we just wanted to make sure there was time for other lingering questions, if there are. If you want to put those into the chat or go ahead and ask those. Thought we'd leave as much time as possible to take advantage of our amazing presenters. So
It looks like Chris Anderson has a question.
yeah, please go ahead.
I read an article about billionaires putting their assets in South Dakota trusts to protect them from divorce proceedings. So I presume that the laws on trusts go by states, and that some states are advantageous for special things.
Yeah, so there are what are called states that have special laws. So the rule generally is, if I create a trust for my own benefit and transfer assets to it, I don't get any creditor protection. But some states have a law for what are called self-settled asset protection trusts, where that rule is different. And so I can actually create a trust that I could be a potential beneficiary of. And so that trust is that, and you can do it either in the US or sometimes you do it internationally. But that trust is protected from my creditors. So you could do that in South Dakota, you can do it in Delaware, you can do it in Alaska. There's different laws, and jurisdictions are trying to fight for having the best laws. So they all kind of compete and make them more and more favorable. In general, though, there are some things you want to be cautious about. If you have a known creditor and you transfer all of your assets to this trust to protect it, that's a transfer and fraud of creditors. Like, that's fraudulent. So you need to you can't make yourself insolvent. It's better to do it before you actually have creditor problems. So there's some caveats with it, but it's not at all uncommon to do that. The other benefit for folks who live like in California, like you do, or Oregon, is that these trusts can be set up in a way to avoid state level income tax. So only if a distribution is made to a beneficiary in a state that has an income tax is income tax paid on the state level. So we will do this sometimes with somebody who's maybe going to be selling their business. They transfer it to one of these trusts and then they can avoid some capital gains, although there are a lot of reasons why that may or may not work. But yeah, so I think South Dakota is one of the first states to do it. These states also allow trusts to go on forever. So for example, in Oregon, trusts are going to generally after 90 years have to end. Washington, 150. In South Dakota, they could go on for eternity. So there's an ability to avoid the generation skipping tax I was talking about on those assets.
So a different kind of question. If you're retiring abroad, what state is the most advantageous to have as your US residence?
So it is theoretically possible to live abroad, be subject to federal estate tax issues, but have no state of residence because you don't actually live anywhere. So that's one option. And then the other option would be to pick a state that doesn't have an income tax or an estate tax. So, Nevada, Alaska, something like that, if you did actually need to create some sort of jurisdiction that you were living in for some reason. But it is possible if you have no ties to any state in the US to be stateless.
Thank you. Other questions?
Yes, I left a question for Susan and Mark, but anyone could answer it if they.
Hi, Nancy. Yeah, I saw your
Oh, you
question,
did? Okay.
and actually I have one just like that right now. Nancy's question is sort of about whether you have with assets of dubious value that cost money to maintain. So in Nancy's case, her mom cast owning little bits of vacant land in areas that have still not been developed and still aren't worth anything, but there's property taxes due. And Nancy knows if she doesn't pay the property taxes, then the local county assessors, tax collector is going to sell that property for the taxes and they'll lose them. And Nancy also knows that her daughter doesn't want to give up the property, as it's hard emotionally to give up anything. So
She'd be happy if I sold them or did something, depending on if any of them are of any value or look like they might become valuable.
All right, and the part of Nancy's question that may be of even more general interest is what to do when you've inherited something, but you never changed title to it. So mom died 3 decades ago and nobody ever wanted to pay to open a probate in every state, which probably would have cost more than the land was worth
You got
to
it.
deal with
Exactly.
transferring title. But it's never too late to open a probate. There's no statute of limitations. You can always do it. And in a way, you don't have to do it till you sell it. Now, how do we sell property in the US? How, when you buy real estate, do you know that the seller had good title? We have title insurance. Title insurance runs the whole thing. So title insurance is interesting in the fact that you just have to do whatever pleases them, as long as you can provide that policy of insurance to the buyer. So you can almost wait till you're ready to sell real estate. And sometimes they'll just take an indemnity offer. If Nancy swears that she's the beneficiary of this land and provides mom's death certificate and maybe the will and says, title company, if it turns out I'm not the owner, I'll pay whatever you have to pay out on the policy. They might accept that. Or Nancy may have to do, she might have to open a probate at that point. It's, you know, and so I have one of these right now where it's actually more extreme than yours, Nancy, because the kid only owns the vacant land as tenants in common with another family where the parent died. So you only own half the property and they're debating what to do. And they're trying to wrap up, you know, an estate. So, you know, so those things, I think you have to weigh it. If you could get some money now, you're probably better selling it, because in economics, if any of us took economics, there's a thing called opportunity cost. So while your money's sitting there, it's not an Amazon, it's not an Apple. There's a lot of things to do with your money. It's not like the money's going to go poof if you sell it. So it might be worth selling it because you at least know the story, right? You could at least, whereas if you pass, then your daughter has to go through 2 levels of probate. She needs to probate from your grandma, and then from her grandma, and then from you. And it's just adding to the expense and uncertainty.
Good answer. Thank you. Very
I
helpful.
see. I see Murray has asked how one would open a probate. And so remember, probate becomes necessary if someone either dies with a will and no trust, or if someone dies without any estate plan. And in that case, and again, there's a threshold amount of assets that that person, now called the decedent, would have to have in order to force a probate to need to be opened in order to transfer the assets. So basically, the person who is nominated as executor in the will, or else usually the person who is going to inherit, if it's an intestate situation, will go out, find an attorney who does probate, and then the attorney will prepare what's called a probate petition. And the purpose of the petition is to appoint either an executor in the case where there's a will, or an administrator in the case where there is no will, or where there is a will that does not name an executor. Then there's even another role. It's called being an administrator with will annexed. And all of these individuals are known as personal representatives. And initially, that person gets appointed at a hearing before a judge, and then the judge issues a court order. And at that point, something called letters testamentary, where there is an executor, or letters of administration, where there is an administrator, or the administrator with will annexed, will then be issued by the court. And the executor or administrator now has authority to go and manage the assets of the decedent. So that person will secure assets by maybe changing locks on the house. That person will go and open an estate bank account and transfer other assets into it, and then basically take on the management role If there's a business, an ongoing business, that person who's been appointed can now run the business and hire professionals to do these things until the point where and pay creditors or any, debts that are due, until the point when the administration is ready to be closed, and then that person will have their attorney prepare a petition for an order for what we call final distribution. And once that hearing is held and and an accounting usually filed as to what was spent and what was what came into the estate. And once that hearing is held and the judge approves that petition, then the executor or administrator can distribute the assets. And I forgot to mention, and they have to pay the taxes, of course. Taxes always need to be paid. So, and yes, people can do it themselves, but they shouldn't, because there are a lot of specifics involved.
Does this have to be a state and county court, or can it be a federal court?
Oh, it's probate is state by state. And generally we file in the county where the person resided when they passed away.
So just as a follow-up question, in addition to an attorney, what other sorts of professionals might help you with an estate plan?
Good.
Well, I mean, only a lawyer is authorized to practice law. And so these are legal documents. So you're going to need a lawyer, but your lawyer will typically work with your accountant or tax preparer, and may also seek input to talk to your financial planner if you have somebody who helps you manage your assets, to get a better understanding of, make sure assets are titled and beneficiary statements are as you like them, and to understand better what you hold. And oftentimes it will be your accountant or financial planner who will say, I think you need, if you don't have an estate plan, I think you should have one, or this is how it, I think maybe you should talk with your attorney about this strategy or something like that.
Thank you. We have time for maybe one more question, if there is one.
I have another one if there is no one else.
Yeah, please go ahead, Lynn.
Okay. Mark, you were kind enough to encourage us to see a lawyer and see a lawyer often. I tend to be a little bit more miserly, and I want to do everything myself that I possibly can. And in that regard, I have a question regarding Susie Orman. Now, Susie Orman sells a will and trust kit for $69. And it has 4 documents in it: a will, a living revocable trust, financial power of attorney, and a durable power of attorney for health care. Is that package worth buying and filling out? I mean, your advice may be, well, yeah, but take it to a lawyer later, but is that worth buying and filling out?
It's good for Susie Orman because she'll get some money, and I'm not sure that it's good for you. I understand, I definitely have clients who are engineer or that sort of type who like, fully understanding and doing things themselves. But I know, like, Susan has many estate planning clients who actually are attorneys, and so in a way could do this sort of work. But it's really better to go to someone who does this kind of work. And Lynn, you can kind of see that there's something about human perception that we don't know what we don't know. The brain is kind of wired to think we know enough. So you don't really know what you're not seeing because it's just not your specialty. So you could get black ink on white paper, and I'll sell you black ink on white paper for half of what she sells it. But otherwise, I don't think it's worthwhile. I mean, if you can't do anything at all, and what I recommend, and probably Vanessa and Susan would agree, if like you're like, you don't have anything at all, and suddenly like you're on the way to the hospital or you're afraid you're going to die. Just do something totally in your own handwriting and say what you want. That's probably the best thing. If anything more than that, go to a lawyer.
Okay, thank you, Mark. Thank you very much.
And sign and date it.
Right.
Okay.
And get a witness on it.
No, you
No.
don't need a witness. If it's all in your handwriting and you sign and date it and call it my will.
Thank you.
And that depends upon the state. So
Of course.
that's like,
We're
you know,
not, caveat also, none of us, Vanessa, Susan, or me, are giving legal advice that can be relied on. This is just general education, fun for
Yeah.
an alumni event.
I can also say your descendants will pay for it. So I think it's whether you pay for it or they pay for it. Think about it that way. Is it a gift? It's a gift you're giving the people who are inheriting it.
Thank you so much. So it looks like we're just about at time. It's my profound pleasure just to say thank you to all of our attendees and particularly to our presenters. Susan and Mark and Vanessa, thank you so much for joining us, providing us with this information and sharing your expertise. The gift planning team is going to follow up with an email tomorrow with contact information for our presenters and ourselves. And then sometime next week when the recording is available of the main sessions, not including the breakout rooms, we'll make sure to share that as well. So everyone, thank you so much. Whatever you do for the rest of your reunions, we really hope you enjoy it. And we'll be in touch soon. Thank you.